Okay. Ms. McDougall, why don't you ask the questions relative to the concerns about dissemination, if you could, please.
Let me just clarify before I ask which tests Ms. Regan intends to ask about so I can focus on those.
Sure.
The MFAST and the Sears. Now, I have to hear the direct before I know for sure, but right now it's my intention to question the specific questions on these tests.
Go ahead. Yes.
Dr. Heaven, with respect to the MFAST, are there any terms or contracts under which you receive the MFAST to be able to administer it?
When we are able to purchase these materials, we do this by demonstrating our credentials, that we've had adequate training in the administration, scoring, and interpretation of tests. So we have to attest to the fact that we have PhDs in a relevant area of psychology before we can purchase the test materials. And in doing so, there is a contract in which we agree not to disclose the test information to people not qualified to use those tests.
And certainly the publisher or the owner of the test understands there may be limited circumstances under which you do have to disclose them. Do they request certain terms for those disclosures?
They do.
And what are those terms generally?
Generally, that any kind of individual test item is not released to the general public, is not recorded in any way. The reason being is that if this information gets out into the general public, it can serve to invalidate the test for any future use, because understandably, people then might take that information outside of the courtroom and instruct individuals on how to take the test. It would be basically like releasing the LSAT questions or something like that, which would invalidate the test and require new development of new tests, which is of course a very expensive process.
And Doctor, to the extent you include information regarding testing in your report to experts or report to the court, you understand those reports to be submitted under protective orders. Is that correct?
In my report?
Yes.
Correct, but I don't put test questions in my reports.
And is that the crux of the problem, the actual text questions appearing in public or in the report or somewhere someone could access them?
Correct.
And is what you've described with respecting to the MFAST, is that also true of the Sears?
Correct.
So essentially for any of these tests it would be true, is that correct?
Correct. We are required both by our ethical principles and by intellectual property law to not disclose the particular test items.
And disclosing them would be a violation of your contract absent specific court order, is that correct?
Correct.
Disclosing them would be a violation of the copyright of the publishers, is that correct?
Yes.
And disclosing them would present an ethical problem for you, is that correct?
Correct.
And can you describe the ethical problem for you?
Well, in our ethics, in the ethical principles of psychologists, our code of conduct, there is a whole section, I think it's the standard sections 9 and so on, that discusses when, for example, raw test data can be released and when test materials can be released. The former, raw test data, can be released under certain stipulations. The latter, test materials, cannot be released. So we're not allowed to provide, for example, test manuals to attorneys or to people who are not allowed, who could not purchase those materials on their own from the test publishing company because they don't have the credentials.
And I think you've articulated this, but if you could, let me ask you this. With respect to the MFAST and the Sears in particular in this case, both of those tests are tests of potentially of malingering, is that correct?
Those are tests that are specifically designed to assess for the presence of malingering.
So having someone who's being tested have access to those test questions ahead of time could greatly damage the testing of those people.
That's correct. I mean, we've actually seen that for some tests that have been released. If you were to Google a particular test
Well,
and...
that's what we're doing right now, actually. As you speak, I've got the clerk Googling to see what we can get and what we can't get.
No, but what I'm saying is that some tests have been compromised because information has appeared in the media, and so we actually anticipate that we can't use particular tests because they're no longer valid for the purposes of which they were developed. I'm thinking in particular of the test of memory malingering, which we really have to be careful about.
So we're looking, I asked the clerk to look up whether you can get these MFAST questions and Sears questions on the internet, or whether you can just go on and buy it. So I guess the first question is, can you go, as the clerk's trying to do right now, can you just go on the internet and get these questions?
You should not be able to unless someone has illegally put them up there. Very often when, like if we're Googling something, looking for information, and you stumble upon someone who has disclosed information, typically you contact the test publishing company and they'll get it taken down. I don't think you're going to be able to find the Sears and the MFAST questions on the internet. You certainly find scientific studies related to them.
Mm-hmm. Okay.
And if I could just approach the witness, Your Honor?
Sure.
In the break, you went on the Pearson website, is that correct?
That's correct.
And is Pearson the publisher of one or both of the tests we're discussing?
I'm not certain. They're just representative of the attitude of the legal policies of the various companies.
So the legal policy described in that document would be consistent in your experience with the legal policies of all the publishers of these tests?
Correct.
I'd ask this be marked for ID, Your Honor. And Doctor, in addition to the other issues you've described, does the legal policy and your own understanding of your ethical obligations recommend you make a call to the American Psychological Association when these issues arise?
To some sort of ethics organization that, or ethics department committee to help us figure out how to deal with these kinds of issues.
And have you and Dr. Kinshirf been endeavoring to do that during the time we've had this morning?
Yes, we've been unsuccessful at this point in directly contacting anyone. There's an email out at this point. His phone calls didn't work, but I don't believe we had a response yet.
If I could just have one moment, Your Honor.
Sure.
I have nothing else for this witness for this.
Anything on this issue?
No.
All right. How about you mentioned that these tests are used in a lot of situations. Like, for instance, what happens from your experience in a sexually dangerous person case, or well, care and protection wouldn't be a good example because that's a closed courtroom, when there's examination about raw data, or have you not been in that situation?
I have not been in that situation.
All right. All right. Well, this is my thought. I don't see, you can step down, Doctor. I may have some questions. Actually, maybe you should stay there in case I need some follow-up questions. Here's my thought. There's no reason to close the courtroom. The court does not need a reason for there not to be any audio or video of a witness. There's no right to it, so I don't need any reasons for it. So the only thing that's left is the print media, and I'm thinking out loud here. I think what I could do is just leave the courtroom open and have any members of the print media come inside and tell them they're under an order not to write concerning the questions that are part of these tests and the answers that are part of these tests. in any news story or in any other way. And that requires, since it's a prior restraint, a serious reason, very serious reason. I credit the testimony of the witness, and the serious reason that's been articulated is that two of the, and this is why I'm glad I had you stay on this stand, Doctor, two of the most important tests that are utilized for the purposes of testing malingering would be compromised for mental health providers throughout the country were the court to not order otherwise.
Correct.
Is that a fair statement?
That is a fair statement.
All right. Well, if that's not grounds for a prior restraint, I don't know what is. All right. So what I'm going to do is have court officers, Mr. Lang, just make sure any member of the press who comes in that we're alerted to it, that's not already here. And if I could just ask any print media, the order relative to the cameras doesn't start, not being able to film doesn't start until you get to specific questions. Is that going to be your first area of inquiry?
No.
All right, so when that point comes, you'll let me know. All right, if I could just all...
Just, Your Honor, to make clear that not only can the print media not report on it, but that the audio and digital media can't report on it. Just because they don't have film of it doesn't mean, as we learned when they were down, they won't say it.
No. You know what? I thought that was explicit, but you're right, it's implicit in the order. All right. The court finds that that the testimony of the witness during the voir dire is credible, and that she believes that release of this raw data and answers would jeopardize mental health professionals' ability to treat for malingering would be jeopardized. Is that a fair statement?
That's a fair statement.
Okay. All right. Do you want to be heard further?
Just one little item on behalf of Dr. Hebben, just to cover her on the ethical front, if the court could directly order her to testify to it.
I will. I will when we
In the nicest way possible.
Get to that
Understanding
point.
she's not saying she won't, but just for her ethical.
Yeah, I will. What I'm going to do is, because I think it's only fair, is that there's a problem here. So it's 12:09. We're going to go as far as we can on cross before I issue the order in case a lawyer wants to come in here and file something before we get to the issue. So
Still have a decent amount of direct as well.
good. All right. So that takes care of the issue of allowing time for lawyers to come in and seek to intervene as it relates to the prior restraint. All right. Caitlin, can you talk to the reporter who's raising her hand outside the courtroom? Yes. Okay. All right. So we have testimony that we still need to do, so let's bring the jury in, and then we will continue. All right, court will be in a short recess.